So regarding this witness, let's just, I don't know what the documents are, but I'd like to proffer basically how this is getting in. I understand there's an extraction, and I understand that was done, but I haven't seen what the proposal or the summary from the extraction was.
Here, I have those. If you want to look at them over lunch, I'd be happy to provide them.
Sure. You gave a copy of this to council?
Yes, sir.
Yes, we do.
These would be the ones I'd be trying to introduce as the color copies. They're easiest to read.
So these are for what you intend to introduce at the time of trial?
Yes, sir.
All right.
There's also...
And so council's objection basically was, and again, to reiterate, I let the extraction in because it was taken from the phone. The defense's position is that there's no indication that it's the defendant, Jamell Demons' phone, and your position was that what's on the phone is evidence of who's had care, custody, control, and who was using the phone. Am I understanding the argument correctly?
Correct, Your Honor. And so those messages go to show that as well. So there are some, for example, some pictures and things where pictures of the defendant and the other person involved in the chat are and talked about. That they're acknowledging that is who is communicating with one another. One of those photos has already been introduced. That was the photo that was authenticated by Felicia Holmes. That was the photo of the defendant and Frederick Gibbons, which is also known as Frito Bang. That is the approximately 50-page statement that you have in front of you. Other ones include, there's photos of the defendant with other individuals that are identified, and they're also cross-referenced with the emails that are sent to the defendant's email and retrieved on that same phone, as well as hundreds of photos, selfies, screenshots of the defendant using that phone.
With respect to the authentication, Your Honor, I think there's a little bit more nuance to our argument, which is it's not sufficient to say that the defendant used that phone at some point. I think there's ample evidence that that phone was used by more than one person. And the most poignant and striking evidence of that is that the phone comes back to the name Sack Chaser Howard. What that means, I know that my phone doesn't come back with the name Christine Bradley because I wouldn't do that. And I think that is a clear indicator that that phone was being used by others. And so the issue is not whether or not, if we can show that it was used by Mr. Demons at some time, everything comes in. The issue is if you want to get in conversation A, prove that conversation A, lay the foundation for conversation A. Prove that conversation A was being had between Mr. Demons and somebody else, and that would be at least some measure of authentication. The case law does indicate that one of the two parties to the conversation is the way to go, and that's the way to authenticate it, but it's not exclusive. But each single conversation as it's coming in should be authenticated, because the fact that the phone was passed around and used by several others, we have presented the court with evidence that that phone was being used while Mr. Demons was in custody. We know it's being used by several other people. It's not in his name and it wasn't recovered from him. And so the issue isn't whether or not he's ever used it. The issue is each conversation that you're trying to put in, authenticate it, lay the proper foundation so that we're not risking misleading this jury.
Thank you. And counsel, this is on this extraction report is all on the phone with the 9807 phone number, correct?
That's correct, Your Honor. And just so...
And that's the subscriber of that was Jamie King?
Yes, the defendant's
the information that's from T-Mobile, I forget the exhibit number, but which had the subscriber showed that this 9807 line was signed or used by Mr. Demons, the defendant.
There's other information that the state has introduced, including the pawn receipt, in which Mr. Demons is identifying that as his personal phone number.
I realize that, but I'm trying to go back to this subscriber information. I thought that and I don't have it in front of me, but the plan was a family plan or something, and Ms. Jamie King had one phone, is that correct? And Mr. Demons had a different phone?
There are multiple phones on that plan, including one of the victim's phones that was used by the victim. Mr. Anthony Williams was on that same phone plan that Ms. King was paying for, but the defendant was using. And so in terms of any evidence that anyone else was using that phone, Your Honor, there's been proffers of things that will supposedly be said by the defense. However, there is no evidence before Your Honor that anyone else other than the defendant used that phone. And I'd be happy to put together over lunch a compilation of every single one of the screenshots that the defendant took on almost every FaceTime call that includes him in this small box, which would be indicative of who is using that phone, and the other individuals that he is calling as the larger picture.
Your Honor, some of the evidence is before you now, which is Mr. Williams, who was also on that plan, was also using that phone. His nickname was Sack Chaser. Right before you, you will notice that all of those messages are coming from Sack Chaser. I'm not claiming that that means that all of those messages are from him. I am saying it's proof dispositive that the phone was being used by him at times, or that would never have materialized in that way. And this notion that you go to a pawnbroker, yes, maybe the day that Mr. Demons was at the pawnbroker, he gave that phone number because he knew it was one he could reach. Just like last night when I went to go buy face cream for my wife, they asked, do you have a number with us? And I gave them her number because that's the number that is associated with our Walgreens account to get credits. And when I go to Total Wine and they ask me, I give my number. And that's how that works. And so the fact that he may have identified that as a phone that he could be contacted at when he did a certain pawn transaction is not dispositive proof that he's the exclusive user of that phone. The fact that Sack Chaser's name is associated with that phone is dispositive proof that he was using that phone. And the fact that the phone was being used after Mr. Demons was incarcerated is also dispositive proof that the phone was being used by others. And the way that we can solve this is that the state can lay the foundation for each conversation they want to get in. And if they can't, it means they don't have the proof that it is him. If they can, then they do have the proof, and it should be admitted. But that's all we have.
Thank you. And the phone itself, when was the extraction done?
The extraction was done February of 2019. I believe February 23rd or 28th. I don't remember exactly. It's on the analysis. The report that is generated, which is what's been put in evidence, is generated in June of 2019. This was the phone that the defendant's manager brought to the state attorney's office and was identified during that conversation by the defendant's manager as being the defendant's phone that he was given after the defendant went into custody. There are multiple messages and things that I'm happy to show the court because that item is in evidence, and I can put together a composite over lunch to show exactly the number of times the defendant is pictured on that phone, including the various accounts that have already been introduced, such as the Snapchat account, the email accounts, of which we have the Apple records and the certification on that. For those phones, that it comes back to YNW Melly booking at gmail.com. And that email address, in the terms of when that was created, all of that is also subject to the search warrant, specifically which this witness looked at, which we can talk about the creation date of the account, which predates any of the activities in this case and all of the names that are associated with it of Jamell Demons.
But you're telling me the phone was turned over to the state attorney's office or the police on or about the date when Mr. Demons was arrested?
No, Mr. Demons turned himself in on February 13th of 2019. About 2 weeks later, his manager came to the state attorney's office to give a sworn statement and brought the phone with him.
That's Mr. Francois?
Mr. Francois. The passcode to access that phone was given by this defendant in a jail call that I have, like I mentioned previously, to his mother, where he's telling her how to and what code is associated with the phone. That is how the state attorney's office, with the help of law enforcement, was able to get the full extraction that we have, because this defendant, on a recorded jail call, gave the passcode to his mother.
A couple of things, Your Honor, in retort. One is if YNW Melly is like any other artist, the person who does their bookings is their manager, the person who had phone in hand. So if it's coming back to YNW Melly booking, that would suggest that it's the manager who has possession of that phone. The other thing that suggests he had possession of the phone is he had possession of the phone and he turned it over. Now, the fact that Mr. Demons knows the passcode is, again, not proof dispositive. That phone was being used by others while he was incarcerated. So other people clearly knew the password to the phone, or they could not have used it. And third, I'm not sure that Mr. Francois coming in here and saying it's Mr. Demons' phone would be sufficient. I don't know that that would not be some form of hearsay, but at least that might start to approach some sort of foundation. All the foundation that's required by law to be adduced and elicited and put into the record is coming from the state attorney's mouth at that desk, and it's not in evidence. So all the things that she's saying establishes it as his phone are the very things that the case law and rules require be adduced before that jury. And so the fact that she understands that is evident from the fact that she is presenting it as the foundation for why she's trying to introduce this information. But this is not the forum to do it outside the presence of the jury. Do it in front of the jury if you have the witnesses, because otherwise it's hearsay. Her saying that Joe Blow told her that somebody else owns a phone is not legal foundation sufficient to satisfy the rules of evidence.
All right, so counsel, I'd like to see what you have and show me, we'll talk about how you, what evidence you're going to have introduced to authenticate it and how to come in. All right? So we'll see everybody back at, let's see, 1:15. All right? Thank you.
Thank you, sir.
Now, these are being offered for the truth of the matter asserted, but I don't see what the tie into the defendant, Mr. Demons, is.
Sure, Your Honor. So in terms of all of the messages that you have before Your Honor, the messages in green are the statements of the defendant. So what I did was...
How come they start out with young sack chaser Howard? I thought I was advised previously that that was not Mr. Demons, that he had a different name or something along those lines.
He does, Your Honor. So that is a remnant from Celebrate. I don't know why it does that on there. That's something defense can argue, but what I can show, Your Honor, is on the phone itself, and these are approximately 300 images that I was able to put together in about 15 minutes. There are some that will only show on the computer here because it has the specific codec that is required. But in each of these images, there are 300 of them that I can go through that show the defendant on FaceTime calls with his mother, with his grandmother, and I can go through them individually and show that they are on and from the device itself. So the report that's up on the screen now, Your Honor, will show that sometimes images are sent to the defendant. For example, this picture here, which is the photograph of the defendant and his mother. That was an attachment that was sent to that particular phone. Now, that to be contrasted with for example, this image here, which is showing a file path of the actual phone itself. This is DCIM 100 Apple. This is being taken on an Apple iPhone XS Max, which is the phone that the defendant was using, that is attached to that 772-713-9807. So in total, Your Honor, this is just 300 of about, there's 10,000 images on the phone in total, and this isn't even talking about any of the videos, of which there are many videos on there that also show the defendant on that. You have photos of the defendant, for example, I'm trying to for the screenshots where he is taking, there are selfies, there are images that are taken from various phone conversations in which he is doing a FaceTime. For example, this one right here, if it ends in .png, Your Honor, that is indicative and can be testified to that that is a screenshot. When an iPhone takes a screenshot or a capture of whatever is on the screen, then that's going to be a .png format. So that's what we have here. In this one, you have a photo of the defendant in the small top of the screen, showing that he is the person making the phone call, and then the person he's speaking to on the video chat, his little brother, is there in the larger one. So here's another example of that, and this also shows that the defendant made FaceTime video calls as his regular course of conduct, which goes to show and explain why, for example, there's not a data call, there's data used, but not a cell phone or a CDR. Here's yet another one of the defendant, and it's also, and this is also consistent with being on the T-Mobile LTE network, which are the records that the records custodian testified to and are in evidence. So that is just one example. I have the full printout of what I just showed, of the 59 pages with all the thumbnails of every image as well, to show for Donna on that. There's more, counsel. Yes.
Well, maybe should we take the arguments piecemeal, or?
I'm sorry. What is, this is a different...
Those are the 300 photos that I provided to Your Honor.
These?
Yes, that is now showing the path of the directory location where each and every one of those photos was found, whether it was came to the device as something that was sent to the device as an attachment on a message, or whether it was actually created by one of the devices themselves.
And how about at or about the time of the murder in question?
There are images that predate that, including, and then there are text messages and conversations that are done at or about the time of the murder, including conversations with the defendant's mother. So, for example, I'll show Your Honor now what has been extracted from that same cell phone. And this is also information that predates the murder. So there's no reason or motive to lie or anything at that point, because at this point the victims are still alive. And so we also then have the defendant's conversations before and after, which show the same pattern of speech, the same way he is communicating on these, which show that he is the individual that had care, custody, and control of that phone at the time. So I'm going to start, and I appreciate Gary's help on this one. And this is from a phone number that is identified as...
Your Honor, before we continue, I would respectfully suggest that we take my retort to their argument piecemeal so that we don't lose the significance
Thank you.
of each.
She's going to, counsel's going to proceed with her
Okay.
argument and your thing, and you'll get a chance to speak.
Thank you.
So we have, this is prior to the homicide, this is going to be August 30th of 2018. The phone number 772-501-6942 that's said to a crazy lady. Again, we'll get into why it's a B shortly with the next witness. In this case, this is the defendant's mother. This is Jamie King. Because if you go to State 63 on the subscriber records, that is the other phone number that is subscribed to Miss Jamie King at that time. Additionally, defense counsel provided Jamie King's records to the state to show that that is her phone number and represented it as such. So this is discussions and where he is calling her mom about and talking about the argument and the fight between the defendant, Sack, Chaser, and as he's referred to at this bottom message, where she is talking to Mr. Demons about that person, showing that it is not Sack that is on the other end of this line or this particular phone call. Moving on, and then we also have where a discussion, this is still August 30th, and we're talking about how, I don't know what all going on, he's talking, making a live video talking about your mother. It's going to make people hate you. That's why I have never and would never do that. I love you, and that's your best friend. This is not for social media. And
Sorry,
then,
hold on a second.
sure,
Can you repeat that, please?
Of course.
Too fast.
sure. So, if you go through this whole conversation here, starting with, how is his sister going on social media talking about punching me in the face, my fault, from the individual that's been identified as Jamie King by the phone records, by the subscriber records that are in evidence already. Then going on to reply is, you started it by texting his mama, it's gonna be problems, and not even knowing what you're talking about. You a grown-ass lady doing childish shit. Ain't nobody tell you to text her. She minding her business, going to work, you effing with her. The response then, she could have called me or texted me back, not have you or daughter all on social media talking about fighting me like I cussed at her. I didn't even say one cuss word when I texted her. I said nothing disrespectful and you know it. I wish you took up for me like that when Aunt cussed me out and tried to fight me. Again, this is talking about Anthony Williams on that. So like I said before, the next message on August 30th, I don't know what's all going on. He's talking about making a live video, talking about your mother. It's going to make people hate you. That's why I have never and would never do that, because I love you and that's your best friend. This is not for social media. So continuing on, next page. In this particular page, this is again referring to these social media conversations on that with regards to Anthony Williams and the defendant's mother. So for here, no, I'm not your actions I take up for you. I have people telling me your son doesn't care about you. That Jamell Demons' mother is Jamie King. Here she is identifying that she is speaking to her son in that. So then I want to go then to after the time of the homicide, in which Jamie King is sending a text message to her son, send me your location. I'm in Stewart. I love you so much. He then sends a return the location showing at or about the time of the crime as to who was using and doing that. Okay, love you, again from Jamie King. I'm at your gate. I'm going to get the trash. The next response is bring Mariah, which you honors already heard testimony that Felicia Holmes, her daughter, Mariah Hamilton, was in a dating relationship with this defendant, and that at this time, and that there was conversations, and that she has identified Mariah as Mariah Hamilton. Then there is okay. It continues. He then asks his mother to buy him a Glock ASAP, and telling her, like, go now. So she then responds, okay, what's wrong? She says, I got your 45. Then his response, I just don't want no illegal gun. Well, that's not illegal. Continuing on, but I'd rather have a Glock 40 or a 19. She says, okay. His response is, I'll pay you when you get down here. She then says, okay. Then,
Your Honor, I object to this. Is she going to read the entire phone? This does not go to the heart of our objection. This is being done for the cameras.
Counsel, I asked her to put on a proffer of what she anticipated is what she's telling me and how it's relevant. Go ahead.
continuing on, there's then discussions about other witnesses. I'm waiting on track to cash at me the $1,000. And then she asks, is someone threatening you? To which he replies, no, ma. This is his mother that he's talking to. And he's saying, I'm not scared, just listen. This is clear proof and evidence that this is Jamell Demons' phone because he is speaking with his mother on that one. So on the last one that shows November 3rd, 2018, love you too, ma, and yes, son, on that, where she is identifying that is the phone that is being used by her son, and that is on the subscriber records. However, that's not the only thing. In addition, the defendant also, in other conversations at or about the time of the homicide, sends a photo of his driver's license to someone to be able to authenticate and show specific items in terms of going through and setting up a rental. And even has so much as puts the address of 805 Northeast 4th Avenue.
What's the date of that, Counsel?
That one is September 28th of 2018. That shows that the defendant has previously been to the studio and knows that. Also talks, and this is a conversation with Adrian Davis, in which he is using this phone, sending in pictures of his driver's license from his phone. And some of the other pictures and items that Your Honor has in front of you, there's pictures of credit cards, front and back, with the defendant's name on them. There are multiple things that show that this phone was being used by the defendant, Jamell Demons. There is no evidence before Your Honor that it was being used at the time of the crime by anyone else. In addition, the defendant is seen on camera in possession of a phone as he is leaving the studio on October 26th of 2018. At that point, there's a phone in his hand. That phone then tracks, and you can follow on all of the call detail records and all of the mapping that was done and put in yesterday to show that this phone goes from the studio and is consistent with the phone of Anthony Williams, which is the other phone that's on there on T-Mobile, and all the way out to the scene of the crime. Then it continues until, at which point the phone separates, and Anthony Williams' phone and Christopher Thomas's phone goes to the hospital, and that is what is consistent with that, and they are recovered at that location.
And Counsel, I don't understand this Celebrite, why that would put a different name on the text messages.
So in terms of that, if there is any time that anybody else has used the phone, for whatever purpose on that, if they have logged in on a other social media account, that could put that name on there. However, it is who was using the phone at the time that is important. And so this and all of the information and everything on these show that it was the defendant. And by the defense suggesting it was not, that makes even more items relevant to show. For example, defense counsel brought up and showed images of a very intimate nature that were shown of the defendant. The contention that someone would allow photos of his penis to be accessed and sent out by friends and other people is absolutely ridiculous. So just the conversations that you have read as well include pictures of the defendant and those are in there, with other people in which he is acknowledging interaction with them and the contents of the photos. Those individuals are the ones that are identified as the gang members that he is associated with.
Thank you. Anything else?
For defense. Yes, sir. Thank you. What we have said, which is the gravamen of our objection, is that this phone was used by others as well. The first question the court put to the state was, how come it says Sack Chaser Howard? I was told that was the nickname of one of the decedents. The state's answer is, I don't know. And that answer is not good enough. The court circled back to that question and asked, and the state just said, I don't know if you, on Celebrite, it might capture it like that with T-Mobile, and it could capture it like that if anybody else ever uses the phone, ever. That, first of all, she's not an expert. We have not heard testimony to that effect. And if she is offering testimony as to how a phone can get identified by a certain moniker that is not the defendant's, and her answer is, I think that that's how it might be if somebody used it ever, would run in direct contravention of this notion that he used the phone exclusively. So the state is conceding by its very contention that somebody else used that phone. They're just saying, I don't know when, and I don't know how the name got there. If what the state says is true, that if somebody uses it once, it will thereafter identify the phone in that person's name forever, we would need an expert to say that, not Miss Bradley, somebody who actually has knowledge about it. It would also be curious that if several other social media accounts and what have you are being accessed by Mr. Demons, how come the multitude of times that he has accessed these accounts did not cause the phone to affix his name to that phone? Again, our contention is not that the phone was never used by Mr. Demons. It's that it was not exclusively used by Mr. Demons. So the state wants to show that Mr. Demons used it, and they put up a screenshot of a FaceTime call showing Mr. Demons up in the top corner. That particular call, the state, by that photo, has established the foundation for that photo. The state then makes mention of Jamie King and saying that the phone number that is being communicated with in a certain message is the other phone number that was on that account. The state conceded before the break that there were several phone numbers on that account. So it's not just one, there were several. However, if for some reason this court were to find some self-authentication by reference to a person as mom, maybe that phone authentication for that particular, and I think actually the state conceded it, not on purpose, but when discussing a message, she said that's proof that that particular message or phone call was between Mr. Demons and his mother. That is how evidence works. Now, because she has proved that there are certain photos, and if the court notes, I mean, I have photos on my phone. Everybody here, I'm sure, has photos on their phone. It's not all of them. And some of the photos that were displayed for the court are clearly not selfies. So somebody else took the picture. Did somebody else take the picture because he was a celebrity? Did somebody else take the picture because he was a friend? Did somebody else take the picture because it was one of the people that he associates with, that he's friends with, that takes a picture of him because they're hanging out? That does not establish that it's his phone. That doesn't even begin to establish. As a matter of fact, it puts the phone in somebody else's hand at the very moment that picture is being taken. So the question becomes, what is admissible? The state, if what is clear, is that for all the gang stuff that the state is now trying to seek to admit, all of this identifying information that she can point to for all these other conversations, she cannot point to for the ones that she's trying to put in that this hearing is about. So she's asking the court to extrapolate. I can prove that he had this phone in his possession sometimes, maybe a lot. I can't explain why it has somebody else's name on it. Could be any reason. And I'm going to offer my expert opinion as to why it has Sack Chaser Howard on there that I can't back up by any expert I've ever spoken to. And previously I just told you I don't know how it got there. Conceding that it's not in his name, that it's clearly been used by others, which she said is why Sack Chaser Howard was there, but she figures, I guess it got Sack Chaser Howard there the single time that somebody else used it, and every other time it was Mr. Demons. That's not logical. It doesn't make sense, and even if it did, the state does not have the evidence to establish that. The conversations that are at issue here are all these gang conversations that the state seeks to put in. If I'm not saying that they can't authenticate and lay a proper foundation for any of those exchanges, if they can, they should do so in accordance with the rules of evidence. But they can't say, ignore the rules of evidence as to everything I want to put in because I'm going to show that he spoke to his mother on this phone and spoke to his girlfriend on this phone and spoke to his younger brother on the phone at some other time. That's why each conversation is independent. Each exchange is independent because each exchange is an item of evidence that requires a foundation for its admissibility. So what we're doing is inviting error when we say, okay, we can prove some things. We can't prove the stuff that we're trying to admit, but we want you to extrapolate and infer that since this phone was in Mr. Demons' hand at some point, at a lot of points, then we get to put in everything and call it his conversations. And the state said Mr. Demons was seen leaving the studio with a phone in his hand, and that phone was tracked. How do we know that that's the phone that was tracked? How do we know that that was the phone in his hand? We do not. That is an inference they're making. It's an argument they're making, and they're entitled to make an argument if they can lay the foundation for the evidence upon which such an argument would rest. But just saying it doesn't make it so. There's nothing that identifies the phone that's seen in his hand as he walks out of that studio as the one they tracked anywhere. And, Your Honor, the problem with doing this wholesale, if this witness is going to testify to a particular exchange, lay the foundation for that exchange like every other trial that we have ever been in, instead of saying we can just obviate the need for that because the foundation is going to be laid outside the presence of the jury by hearsay from the prosecutor without a witness. And so the actual particular conversations at issue here are the gang conversations, or the purported gang conversations that the state wishes to admit through this witness. If this witness can establish them, or if the state can bring another witness in here to establish each one of those conversations as being out of the mouth of Mr. Demons or out of his fingers in a text, then they're admissible. Otherwise, they are not. And they're hearsay.
So in addition, Your Honor, I would point out that the cell phone records that have been introduced from T-Mobile include the IMEI phone number and the MSDN, which is the identifying phone number for that phone. All of that information, again, correlates with the other information that's already been put in there showing that this phone was, in fact, Mr. Demons, including, not limited to, what this defense has also been provided, which are all of the Apple records, which show that the defendant on October 29th of 2018 then took and bought the phone with which has been introduced into evidence, the extraction of that, and brought over all the data from the prior phone he was using on the night of the incident, which is the one that was tracked. And that is able to be seen through all of the data, and that is clear from the records from T-Mobile as well as from Apple, and those are items that are admissible as business records and are not hearsay, as we have previously discussed. And that's what I have up on the screen now, so Your Honor can see the fact that the iPhone, and specifically, when I scroll over, goes back to Jamell Demons, YNW Melly booking at gmail.com, and goes forwards and gives an address in Vero Beach, Florida, which is consistent with what is on his numerous driver's license transcripts, which have been put into evidence. And there it goes through and shows all of the phone numbers and everything else for the defendant.
Your Honor, let me just add this briefly. There is evidence that Mr. Demons lived in the same house as several other people. Identifying an address means nothing. The state, I think, mentioned that in its opening. Several people lived in that house. An address means nothing. Secondly, if I want to set a motion on this court's calendar and they show that I called chambers, it doesn't mean I spoke to the judge. I spoke to your courtroom deputy, maybe, or secretary. Artists get bookings by their manager, the person from whom this phone was obtained. Saying that it says YNW Melly booking is proof, or at least a suggestion, that it was used by somebody who books on behalf of the artist. Artists don't get on the phone and make these arrangements themselves. That's why they have managers. If there was a transcript of a proceeding that took place in this courtroom 7 months ago, and it didn't say who was speaking, coming in here and saying that here's a transcript that shows Mr. Howard was speaking on June the 21st, so therefore he must have been the person speaking several months ago, would be preposterous. This example is tantamount to that. And so the thing is, again, I am not contending that there are no exchanges that can come in. I am saying with the gatekeeping function of this court, it is incumbent upon the court and the state to make sure that the foundation is laid for each exchange that is being adduced. We cannot, none of this, I just mentioned, they have none of the exchanges that they're seeking to put in, they can tie to him. Why don't they start with those? They're telling you about stuff that happened months before, months after, not the ones that they're trying to put in. Those are the ones that need to be authenticated, and each conversation needs authentication because it identifies a speaker. And therefore, when the speaker is a defendant, it circumvents any hearsay objection because it is non-hearsay by definition because it's a statement of the defendant. And also in terms of establishing the foundation so that the jury knows that when you show me this and tell me and get up there in closing and said he said this, we know he said it. And it can't be because we have a FaceTime of him and his little brother months before. Each individual conversation needs to be, a foundation needs to be laid for each individual conversation. It cannot be dumped in wholesale. And if they can establish the foundation, it comes in. If they can't, it stays out. But if we just sidestep the whole procedure by saying we're going to let it in because we're saying this is his phone when we have several indications that the phone was being used by others before, after, and during the entire period at issue in this case.
A couple things, Counsel. Number one is I don't have any evidence before me that the phone's being used by other people at any time. I haven't heard that evidence at all. What I do know is that, and what the state's indicating to me and what she's just proffered are pictures on the cell phone which appear to be the defendant, as well as conversations which appear to be between the defendant and his mother, which is extrinsic evidence of circumstances surrounding the use of the phone and the pictures on it. And it seems to me that that's sufficient to show what the state is claiming, that this is his phone. I don't understand, and I still don't understand, there's some, how young Chaser Howard is on that. And to be candidly, I don't have an adequate explanation, but some of the texts that are between the two phones, the 9807 and his mother's phone, is clear to me that is a discussion between he and his mother, and that he's using the phone. Also, the state provided a certificate 6 weeks or so beforehand from the pawn shop that showed that Mr. Demons was using the phone, identified this as his phone. I have that, as well as the subscriber information showed that the mother is listed on the account, and there's multiple phones on the account. In any event, we're going to proceed and see where it goes, but it seems to me that there is extrinsic evidence, circumstantial evidence that this is Mr. Demons' phone.